This talk today is actually more to give you an awareness than anything else. Thank you, Kishore. Uh, the background to this is that a lot of people intersect whatever businesses or whatever station in life you are in your daily dealings, you will intersect with the law. You can't avoid it. And generally speaking, people have a bad experience of that intersection. The law is looked at as something that is problematic, it gets in the way, it prevents people moving forward. How many of you have had experience with lawyers? Don't be shy. Okay. How many of you had a good experience with lawyers? See, no hands. Generally speaking, lawyers are people you don't want to see. You really don't want to see. Because usually when you go and see them, it means you have a problem. But the thing is that if you use the law properly, if you use the services properly, they can actually avoid a lot of difficulties. And today's presentation is basically to say to you who have got ideas, great ideas, how you can utilize the law to protect those ideas, to protect the path those ideas take, and to use the law to advance the position rather than as something that you're using as a rearguard action to prevent attacks, so that kind of thing, because that's generally how people see the law. Ideas are very powerful things because you can't stop them. Once an idea gets root, it takes off on its own, even if the first person who thought about the wheel probably didn't make the wheel, but the idea caught on, someone took it, carried it forward, and went on with it. With the blossoming of the internet, new ideas are presented to people every day. There is more information in a day on the internet than in the entire human existence till 2011. That's one day worth of ideas. So ideas are very rich sources of things, but they need to be protected and nurtured. Now I want you to imagine something. Imagine you're about to start a journey. Some unknown country, you're going for the first time. You're an adventurous sort of person. The fact that you're here on a Saturday means you're an adventurous sort of person. You're looking for new things and new ideas. To start the journey, you start getting prepared. Next slide, please. And that's the usual thing. You've got your satellite phone, your passport, your backpacks ready. Of course, you've got your map. Then you've got your compasses, your first aid kit, your clothing. Need anything else? All set to go? Off on the journey? Next slide. Have you forgotten anything? Is there something you've missed out? Now, most businesses come to this point and say no. Most businesses say we've thought of everything, we've got people, we've got ideas, we've got a factory, we've got land, we're set to go. But you do miss out something. You miss out on the inoculations. You miss out on the things that will protect you from danger. You're prepared to face, but if you're going into an area where there's malaria, you better take your malaria shots. If you're going to an area which has got landmines, you better be ready to face those. That inoculation is what the law is for entrepreneurs. That inoculation is what protects ideas. And you've got to take it at the right time, because it's worthless once the problem arises. It's pointless taking a vaccine after you've got the disease. It doesn't work. You've got to take it before. And that is why this session is run before the ideas take off. Okay? The death of ideas, the death of most entrepreneurs is because they did not take their vaccines. That's the danger. Because your protection for a healthy idea, for healthy progression, means that you use the law appropriately, because it's there for that purpose. And today we're going to take that journey. We're going to go on this journey where you with your idea are going to launch into a company, try to develop the idea, monetize it, bring benefit to society, and we're going to talk about the right inoculations you've got to take, the right times you've got to go in, see a lawyer before you catch the problem or catch the disease. Bear this analogy in mind because it's very apt. Rewards if the ideas are protected, death if the ideas are not. Next one. So what will it be? What do you have to do? The arc of an idea. Ideas are powerful things, I have stated, and everything that you see around you started as an idea. I often wonder whose bright idea it was to burn food, but that's the guy who discovered cooking. You think about it, it's a very strange thing to do, to take something you eat and put it into a fire. But someone thought about it, someone tried it out, and today we have cooking. The idea that sex leads to pregnancies, not natural, was an idea which took a long time to develop. People noticed a pattern that 9 months later this tends to happen, and you make the connection and you go forward on that as well. You know? So ideas, everything you see, the chair you sit on, everything that you see around you came from an idea. Now, that idea then has to be ascribed to somebody before you can protect it. Whose idea is it? Because things don't come fully fledged. The car was not developed by one person. Somebody had to think about the combustion cycle. Somebody had to think about carburetors. Somebody else had to think about tires. Someone else chassis. But there was one person who put these all together, and his idea was the car. So whose idea was it? Who is the person who deserves the protection? Once the idea is there and you've put it together and it's workable, you've got to now take it to the next level. This is where your marketing comes in. This is where your financing, building your factories, expansion, all that will come in at this level. And all of this are based on one simple idea as well, the contract. That two people can agree with each other what the relationship between them should be. Now bear in mind, it's an agreement between two people. It's not one person telling the other person what to do. And this is the foundation for taking this idea through. That's a collaboration as well. It's expressed in a contract, which is a legal concept, but it is essentially an agreement between two people which binds them, which society says is binding upon them. And then once you got your contracts done, you then decide, where do I go next? Because cars don't stay cars. They develop into trucks, they develop into vans. Is that the idea of the same person who developed the car, or is it somebody else's idea? There are similarities, but there are also differences. If you go on YouTube, lots of people's ideas are captured in single clips. They're never the concept is usually not an idea of one person alone. He's borrowing ideas from other people, right? But is it his? Does he deserve the credit? I'll tell you something, you know, every time you sing happy birthday, you're breaching copyright. The copyright to happy birthday belongs to Sony. And when you see that in movies, they actually charge the movie producers for the fee for permission to use the song in the movies, but only for commercial purposes. So you can carry on singing happy birthday at your friends' parties. Nobody's going to come after you, okay? But that is an idea which has been captured. Somebody wrote the song, somebody has got a value in it, and somebody has taken that value. So this is the outline of what we'll talk about for the next couple of hours. Now, during the course of it, if you have any questions, anything to ask, please feel free. If it's something that is useful for everyone, I'll answer it then and there. If it's something that is very specific, we'll save it for the end. Okay, we'll just defer it. But I know because sometimes questions pop up at the moment and you say, I'll keep it till later, and you'll forget what it is. It's got nothing to do with age, it's got to do with human memory. That's what I keep telling myself. Okay? Right. Forbes did a study of, there's one more member of my team, Laila, at the back there. Hi, Laila. Okay. right at the back. She's part of the knowledge management team. Forbes did a study and came up with 5 mistakes, common mistakes or legal mistakes. Well, who cares whether they're legal or not, but they are mistakes. Things that affect startups in trying to take ideas. The first one is not making the deal clear with your co-founders. Not making the deal clear with your co-founders. Usually one person has the idea or people share. One of the classic examples about this was the tussle over Facebook. There was an argument because what really was the arrangement among the co-founders of Facebook, you know? Not starting the business as a corporation, not using the right vehicle or using the wrong vehicle at the time. Formation of companies is the usual way to go, but there is a time to do it. You can do it too early, and there's a lot of money which goes down the drain, or you can do it too late, by which time the vehicle is not appropriate anymore, right? The third one, and this is critical, is not coming up with a great standard form contract in favor of the company. The problem with startups is because you have a great idea, you tend to forget that you need to see yourself as an equal with the person you're dealing with. The tendency is to think, I'm the small boy, he's the big man, so the contract will favor the big man. And that runs into troubles when you become big, when you grow, because it is not in favor of the company. And that's a leakage that can happen when you develop. Second is not considering carefully the IP protection. Now, one of it is that you don't get protection at all. The other is you get the wrong kind of protection. IP has become very complex. Lots of categories, lots of subdivisions. So you've got to make sure that you've got the right kind of protection. And of course, not having the right legal counsel. There's a tendency for the public to think that because a person is a lawyer, they know all the law. I'll let you into a secret. Most of us know none of the law. We look it up when we have to, right? We just know where to find it. But we have our own specialist areas. And I was a litigator for 27, 28 years. And I litigated in certain areas, corporate litigation. I did corporate litigation. I did commercial litigation. If a criminal came to me and said, defend me, yes, I could, but I am the wrong kind of lawyer. I have not got an expertise in that area. So you've got to find the right counsel. The right counsel is not just competency. It's also someone you can have faith in and can build trust with you. Remember that your startup is not a snapshot. It is a movie. It's going to take time and develop. The relationships you form initially with your advisors should be relationships which can continue into the future. Otherwise, there will be problems whenever you have to switch. Okay, let's look at them one by one. The arc of an idea, right? This is the overview of the law in relation to entrepreneurship. You've come up with a great idea, good business idea. I don't know, I mean, it's your idea, so you will not share it with me, but it's a good one, something that people need, something that will assist society, something that people would want. But what do you do next? What do I do with this idea? Well, you develop it. You'll be developing it either at home, at your workplace, at some spot. It will be fairly private initially, then you'll get into a collaboration at some stage with a few people. But at the time you start getting into a collaboration with people, believe it or not, all these laws will start applying to you. And that's just a small summary, okay? I want you to notice the dates. Each of the dates represents when the laws came into existence. Now, the 50s was a time when businesses all started up, so we had a lot of that. Things were a little slow in the 60s and 70s and 80s. But starting from 1999, we have just had a proliferation of laws that affect businesses. there are plenty of laws out there which will affect whatever you do. One which is going to affect all of us is the GST coming in April this year. We have to contend with that. It affects everything, everyone. And there are a whole host of laws like this which are coming out daily. Commercial and contractual laws are coming up at the rate of about 30 or 40 per year. And keeping up to date is important. So getting the advisor in early, getting someone in to be able to see you through is important. Next slide, please. The top ones are the ones which more often than not will affect everybody, especially when you're starting up. Whatever your relationship, all your relationships, whether or not there is a written document, under law is in the form of a contract. Contracts can be oral contracts. They don't need to be written. If I agree to do something for you and in exchange you agree to do something for me, we have an agreement. If we intend to go into a commercial transaction with that agreement, we have a contract, even before the paper is there. So all relationships when you start up, even with your people around you, need to be in contract. At some point in time, you'll have to document this. So it's important to know what those contracts are, when they are binding. So what form of entity should you choose? Now, there are many choices to make. And generally speaking, you will move from one to another depending on the stage at which your idea is, the stage at which your collaborations are. Early on, collaborators usually are either what we call a sole partnership, proprietor or partnership. You don't form a company when you're developing an idea, very infancy stage. That's more collaborations, which is in the form of partnerships. But the law says that if two people share in an idea, there is a certain ownership of that idea that both share as well. At some point in time, you want to be able to take the idea and run with it without a personal involvement, then the company comes into being. Or you may want to stay a partnership, but have the same benefits of a company of limited liability. This is now a possibility. In some cases, you want the idea to be collaborative. The internet very much developed down here as a cooperative enterprise. Certain people got together, kept the idea among themselves. DARPA was the initial blueprint, which was a Defense Department cooperative enterprise between universities. Later on, developed into a company, which now is basically the internet. Okay, so which should you choose depends on where you are. Here is just to give you some ideas of what the differences are between them. Just to give you some business stats. Now, most people think that the main form of business vehicle in the world is the company. It is not. It is not. Most businesses are just businesses. They're sole proprietors or they are partnerships. So this is the Malaysian statistic from 2012 right to 2014. These are companies, these are proprietorships and partnerships. And you'll see that the vast vehicle is that. Why? Because the man who runs the sundry goods shop doesn't need to have a company because he manages quite well and doesn't have to pay fees to company secretaries, doesn't have to set up board meetings, doesn't have to get directors. It makes sense for him commercially. But if he wants to become a supermarket, then he'll move up to become a company. More structured, he doesn't have a personal involvement. He sits as in a different capacity. So most businesses are here. Most SMEs are here. They're not down there. So bear in mind that there are two types. Sole proprietorship is the easiest, and generally speaking, except in very, very rare cases, most ideas which develop into a full-blown thing start with one person getting an idea, working on it himself. Usually in the creative arts, that's the way it happens. Very few collaborative artists around. Artists tend to be individual, you know. Songwriters tend to be collaborative. That's their scene. So the simplest form of business organization, minimal legal requirements, usually, like I said initially, owned by a single person, and you give it an implemento by saying, the business is me, I'm running it. Now in Malaysia, you can actually register this as a business. And it is useful to register it because it means this is not my hobby anymore. It's become a commercial enterprise. And when it becomes commercial, it carries a value beyond that of a hobby. So your initial one could be simply to run down to the registrar of businesses and say, I want to register myself as a sole business, right? A lot of ideas now for people who work out of their own homes, either making cakes, usually it's in the food industry, or selling ice cream. Dancing Polka is great. I love the ice cream. They work out of their homes. And they register it as a business. So they are a legal entity, legal in the sense they recognize as that. They have to pay their taxes, they have to do that, but their recipes all will be protected because they're used for a commercial purpose. Right? So bear that this is the easiest one, and usually the first way you start. Next, please. CCM regulates it, companies. Most common that we deal with every day would be this, the corporate structure. I think most of us are familiar with this. The benefit of a corporate structure is that the lawyers will say it's a separate legal entity, which nobody knows what that actually means, but never mind. It merely means that it has an artificial existence of its own. Why is that important? I don't need to run it to own it. Whereas if it's a sole proprietorship, I have to run it to own it, right? So I can form a company, get other people to run it, own the shares in it. So I own it, but I don't run it. I can go on and do other things. So it's an ability to divorce yourself from the vehicle. So it carries on its own, but you're getting the benefit. That's the big benefit of a company. The second one is your own liability is protected. Because the company, if you put 100,000 in the company, that is all you will lose if the company is unable to pay its debts. So there's a shield. That's the additional protection. And there will come a time when you're expanding, when you don't have the time to run it as your own business, that you want to think about the structure and say, okay, it was my idea, I've developed it, I got a business now going, right? Now I can't concentrate on making my ice cream in my own house. I've got to get other people involved, but I also want to go into other ventures. How do I leave this behind? You incorporate it, make it a company, get people employed by the company, you own the company, it runs, you can supervise it from the board of directors or anyhow you want to supervise it, and you can go on and spend your time developing other ideas. So that's the benefit of a company structure. It's regulated by the CCM, also a registration, and you would have to go, and there is a cost element we'll come to later. It's more expensive than running a business by itself. The LLP is new in Malaysia. You got to understand that because of our tradition, we are what we call a common law country. We came from the British tradition of law. There are two big traditions of law in the world. There is the common law tradition, which is the British tradition, and there's the civil law or the European-based model. And there are things in the British tradition which the Europeans do not recognize, or the Europeans have which the English don't recognize. The limited liability partnership was an idea that came from the European tradition. It wasn't part of the normal thing, so it's new for us in Malaysia. The Act was incorporated 2 years back. We got some already, and this enables you to combine the benefits of a partnership, so you're fully involved, But your limited liability comes by saying, I'm only involved in this part of the business. So let's say you're working in a collaboration with someone. You provide the ideas, he provides the technology. Now, if the technology goes wrong, you don't want to be the one responsible. If you're a partnership, you will be responsible. But you want to be in charge and hold the design elements because that's what your contribution is. The LLP would be your vehicle because the design element will be his. If things go wrong, your partner will bear the losses. The design elements will be yours. So you can protect yours, he can protect his, and you got mutual protection with each other. So there are more and more these kind of hybrid vehicles coming up. And in the next few years, in fact, Labuan has got the full spread now, but most of us will not go through the Labuan vehicle. So bear in mind that as things move forward, the idea is to encourage entrepreneurship, and to encourage entrepreneurship, you want flexibility. Flexibility means you need to get more and more hybrids out there to meet different needs. So this is where we are at, but we can move forward as we go into the one of the downsides, sorry, can you flip back to that thing? One more down, please. One of the downsides here is that partnerships don't get taxed as partnerships, but LLPs get taxed as companies. But you have to weigh up benefits and losses. Okay. Here is your cost comparisons. Setting up is usually a one-off cost, and you will notice that sole proprietorships, there's no recurrent cost really. There's a renewal application. So what your costs, partnership and your initial setup cost is one-off, it's done. But there are recurrent costs if you run a company on LLP. There are compliance fees here. There are other things which are hidden, which I have not put out here, but you need to hire a company secretary. You need to have board meetings. You need to have a registered office. So those are recurrent costs. But you can tell from the cost elements that this is the cheapest, this is next, this is the last. So depending on where your business is and how much you want to spend in terms of the development of the idea, you pick the appropriate vehicle. It's not a one-size-fits-all, you know, so you got to think about which one. Yeah, sorry. Paid up cap is here, share cap. So if your paid up is, if your authorized capital is higher, you have to pay more to set up the company. If your authorized capital is lower, it's less, this setting up. But it allows you then to issue shares, and people who pay for those shares, that's their full commitment. Your paid up cap is the extent of exposure of individuals to the company. Company goes down, you just lose your paid up cap. You don't lose anything else. But there is something I have to tell you about this now. Over the last few years, especially since the global financial crisis, there has been a global movement to hold directors and senior management officers to some extent responsible for the failure of companies. So more and more now there is legislation which says that if anything goes wrong with the company, they look to the directors and senior officers and ask them to show that they have taken steps to prevent the company from collapsing. So basically show that it's just times were bad, that there was no fault on the way you ran the company. So the liabilities are getting higher now. So the protection may not be enough now. Generally, we now recommend to our directors and senior officers that they should take out a professional liability insurance just to cover D&O insurance, directors and officers insurance. Okay. Ideas is developing, things are going great. You've got your spot on YouTube, you've got your website, you've got a channel on the net, inquiries are coming in, the money starts flowing, now comes the battle. Because if you haven't decided at that point in time how your collaboration is going to sort out ownership, you'll hit problems. Whose idea was this? what part did I play in the development of this idea which is now taking off? What part did I play in the new cooking technique which everybody is beginning to use? What idea did I play in the development of this gadget which has suddenly gone viral? Right? Whose idea was it? Yeah. This comes to the realm of intellectual property. Now, first, confession. I know as much about intellectual property as I probably know about Swahili, which is not very much. But there are intellectual property lawyers who are specialized in it, right? One thing I know, and generally is the case, that intellectual property is limited to the country in which the registration takes place. So if you register an interest in Malaysia, you are not protected outside Malaysia. There has to be registration in those markets as well. There is an element of usage as well. So if you come up with an idea and you go on to protect it and you find out that somebody else has gone ahead of you, too bad. Unless you can show that your idea was there long before and that person may have developed it from years. It's a very complex and it's a bit of a minefield. But the safety net is this. The minute you get registered, you get protection. So intellectual property is a way of taking an idea and giving it ownership. Things are easy to own. I own a book, I own a chair, I own a car, I own a house. I own an idea is a tougher one. So there is paperwork involved. So there are certain things which can be protected and other things which can't. So let's look at what can be protected and what can't. Lots of laws governing this. There's the Copyright Act, which generally deals with artistic property, if you like, writing, music, right? Those kinds of artistic works. Industrial designs with industrial processes. You know, your conveyor chain, your processes involving in the production of certain types of chemicals and stuff, that will be industrial design. Trade descriptions is your names and your brands. Coca Cola would be under, a marketing process would be probably a trade description, a description of how things work. Trademarks are the actual marks. The color of Coca Cola's logo, Google's particular format. MaGIC, that's a trademark. You know, those colors, that wording is protected, is given value. Patents are generally scientific or engineering inventions. You know? So they have to be pretty descriptive. You have to file a patent. There are people who are known as patent writers who are able to describe in language what a three-dimensional object looks and does and its moving parts and what, you know, how that works. And geographical indications are our, well, like ways, things which are able to identify where you are and give a description of where you are. This is a very IT side. One thing is that this has been admitted by most countries in the world as being insufficient. The challenge of information technology is such that our current ways of protecting them in the legal framework are insufficient. There is a huge debate going on, and some countries have gone on board and some countries have gone the other way, as to whether copyright protection or intellectual property protection is actually stifling innovation. Because ownership means you assert ownership, which means somebody else can't use the idea, can't take the idea and work on it. Think about open source as opposed to protected code. If it's open source, I can take it and develop it. I can become a developer. I don't have to worry about it. But if someone owns the source code, they may not give it to me. They may not sell it. I cannot build on that platform. India is probably the best example of someone who's just not hopped on board the protection, and for them it's pharmaceuticals. India will not sign any worldwide protection rights agreements because they can't afford to pay the big pharmaceutical companies the cost they're asking for the drugs they produce. So without signing it, you can go and generate a generic one, and the company which comes up with the drug can't come after you in that territory because that territory does not recognize the protection. So those are generally what these protections are about. The whole branch of IP protects ideas, not things, ideas. So when you create and patent a device, it is not the device which is protected, but the idea behind the device. What the device does, what is unique about it. It's a very complex area because two people may have very similar ideas but doing significantly different things. Is it the same or is it different? And there will be battles fought on that. You all probably know of the ongoing Samsung and Apple saga. They're going to go at it for another 10, 15 years because the technology is so similar, can have parallel development, and each one is claiming ownership. In different territories, different people are winning the legal battle. So it can be something. So what does the law protect? Literary works, musical works, artistic, sound recordings, films, broadcasts. All the stuff that is on YouTube can fall under copyright protection. You know? And in fact, I just did a quick survey yesterday. Most of the stuff on YouTube actually breaches copyright because they use elements of other people's works. And I'm pretty sure they didn't get permission. You know, the only thing is a lot of people just can't be bothered to chase them down. But if you start becoming commercially viable, then people start chasing you down. So then you've got to look at protection coming in. When is a work the same and when is a work original is a big question. It's a big question. But the idea is that if you've got artistic works and you think that they are commercially viable and you need to get them out, the idea is before you go further down, seek your copyright protection. Because once, and it's very easy to get copyright protection, because once it's there, you have asserted ownership. You've got a stake. And if someone else then later on comes up with a very similar idea, you're first in time. How difficult is it to get copyright protection? If you can post yourself a self-addressed registered envelope, you've got copyright protection. Basically, if it's a piece of music, you would record it and post the recorded version back to yourself in a sealed envelope. So you have the postmark, date stamp. So if someone else later on comes and says, hey, that's my idea, you produce the envelope and say, I came up with it first. See the date stamp, it predates yours. It's as simple as that. But it's worth doing for original works. Okay? Yep.
On publish work, similar to what you said about YouTube.
Yep.
So if you publish articles and things like that on your blog,
yep.
is that automatically your problem?
Yeah, whatever you publish on your blog will be yours. The difficulty sometimes comes when you are quoting or taking extracts from other people's works. Then it becomes problematic. But if it's if I write something on my blog today, copyright is mine.
But if there's a certain allowance for quoting a sentence or something, is it?
Yeah, you can take it as long as it's not a major. I mean, certain phrases are common phrases anyway. Certain phrases people have already put out and said, okay, use them. You know, stuff in a newspaper, for example, is for public consumption, so it's not protected in that sense. But if it's a feature article in a newspaper, then you need to get whoever the contributor is technically to get permission. Usually, I will tell you about a very strange case in a little while about this. Whether a selfie taken by a monkey can be copyrighted. But usually, what happens is that it's when the person asserts ownership that the challenge will turn up. And then you have to prove that you got permission. If nobody challenges, then that's really the way it's gone now. So more often than not, if it's a commercial enterprise, most people will ask. If it is a social enterprise, most people leave it unless someone asserts, then they will remove it. You know, so far no one has gone to the point of going beyond, if I assert and you remove it, I'm still going to come after you. So that's the thingy. There's no magic in copyright protection. All you have to establish is that it was your work and it came before the other person who says it's his. That's all really there is. The question arose where there was a particular photographer who, went out and during the course of it dropped his camera, and a macaque monkey decided to take it and took a selfie of himself. So it's the selfie taken by the monkey. Of course, the camera belonged to the photographer. So he developed the film and he posted it on the net, and people liked it, so they started copying it, and he began to assert that that was his work, that he owned the copyright in the photograph because my camera, my film, my work. Went to court and all that. Actually, it was a big battle, and the court said, your camera, your film, monkey's work. So you don't get protection. So, it was in Europe actually, but the challenge was in the US. So it has to be your work. Okay, so what can the law protect in trademarks? It's the mark itself, the design and the lettering, the coloring. So all these would be things that can be protected. Now the word can be a common word, but it's the word that is used in the design and the design of it that is protected. You know, Kentucky Fried Chicken, all three words are common, but that particular way of writing Kentucky Fried Chicken, the logo, our famous kernel, all that is protected. The trademark is protected. Brands are protected under trademarks. So if you've got something which is getting popular, and especially when public starts referring to you by a particular name, that's when you want to start thinking about protecting that word, that particular way of doing it. You can't see it here. Do we have our ZICO thingy? Oh, it's here. This, for example, forget this. This is a trademark and it is protected. There needs to be a registration, but you can't register it. Now, I'll tell you how this came about. We never, when I was with the firm, we were Zaid Ibrahim and Company. That was what we were. But foreign companies and foreign clients who dealt with us found Zaid Ibrahim and Company difficult to say. I don't think, but so they started calling us ZICO, mainly because there was a footballer by the name and they could call the footballer ZICO, so why not call the company ZICO? So for 2.5 years, we kept telling people we are not ZICO, we are Zaid Ibrahim and Company. After 2.5 years, we gave up and said, okay, we are ZICO, right? So that's how the ZICO came about. But the minute we began to be associated with the word, it was time to get it trademarked. So we had to come up with a particular design, particular word, and use it. The story doesn't end there. When it came for us to get a domain for our law firm, we went for www.zico.com, and shock and horror, it's already been taken. There is a company, a subsidiary of Coca Cola, in the US, which sells coconut water drink under the name ZICO, same color, same font. That's how the law got added on, to distinguish it from that, you know. So we get protection under services, basically, the class of category, from that mark, So the protection of the mark is in fact the protection of the brand. Like Coca Cola, it's a brand, it's become. So whenever you've got something which starts becoming popular, a name, think straight away, I need to get this protected before I lose out. In the past, there have been cases where fairly ingenious people have seen the possibility of a foreign brand coming into Malaysia, and what they then do is they start the same product in that range and they get it copyrighted, get it trademarked. So when the foreign brand comes in, it's already locally associated with the local product. The foreign brand has to give way, right? What was the curry one? McCurry is a classic example. Associated with that particular product, McDonald's couldn't displace them. But if they were new on the market, name not associated, people don't know it yet, McDonald's could have displaced them. Okay? So bear that in mind, trademarks. Patent, well, all this can be patented. Now, it doesn't have to be a totally new idea. How are we doing for time? Oh, we got 10 minutes. It doesn't have to be a totally new idea. It can be an inventive step. The inventive step that Henry Ford did was the conveyor belt. Every part of the process was already being done, but he brought the belt into play, substantially increasing productivity. So, a step which is not obvious to a person having ordinary skill in the art. Right? So, coming up with a better wheel probably will not work. That's pretty done to death, an idea done to death. Right? You know cat's eyes, have you come across the term cat's eyes? You know, when you go on roads, sometimes to mark out the center, you have these reflective pieces of metal put in. Now that patent is owned by a German who came up with that design together with the reflective surface. Now it's just a piece of metal, but the idea of using it as a marker was something that could be patented because it was not an obvious step. Now the wonderful thing about patents is once somebody comes up with the idea, everybody else says it's obvious, which is the way it tends to go. But usually it's the first person to come up with the idea that they're going to get it patented. The other one is that applicability. So if you take an idea from one industry and say, hey, I'm now going to try and use it in another industry, nobody has thought of using it in that industry for the same purpose, you can patent that as well, the industrial application. You know, the industrial application. Post-its is a classic example. The people who were developing post-its were looking for an adhesive, a strong adhesive. And all they could come up was a weak adhesive. And he said, hang on a minute, the weak adhesive can be useful in the stationery industry. I'm looking for it for industrial applications, stick things together, but I can take that process and apply it to stationery because there they don't want it to be permanent. They want it to be easily ripped off, protected by patent. So that idea of using that process for that industry is protected by patent. So that's how patents work. Yeah, we'll just finish there. Okay. Now that's what can be protected. What can't be protected is stuff that is already out there. You can't copy, basically. You can't patent what somebody else has come up with and has made public. You can't patent the internet, I'm afraid, because everybody knows it's there, and the founder has decided that he's not going to take out a patent. Tim Berners-Lee has given probably the biggest gift to mankind in the last 30 years. He gave mankind the internet, and he's not charging for it. He says it's an idea which I am giving out for free, so none of us can go run down to the patent office and say, give me a patent, it's a great idea. It's already in the public domain. It's already everybody's. So you can't patent ideas which have come up. You can't patent with an incomplete idea. Usually you got to develop it to some extent. You know? So idea must have some element of form. There's sometimes an argument about is it sufficiently developed to warrant a patent. You know, genome sequences are a classic example. I can come up with a sequence, But if I don't know what it's for, it's an incomplete idea. But if I come out with the sequence and say it can be applied in this particular way by this particular process, it's an idea which can be patented. Okay? And if it's already registered, then you can't. That's why registration is important. It gives you priority, it gives you protection and ownership. Okay? So whenever you get to a point where your invention is about to take off, it's already become usable, your name has already become known, right? A process is already about to be implemented, that is the time you should really pop down to your IP lawyer and say, I need to protect this. And they will advise you how to protect it. Because once you get the protection, it's yours, you're comfortable. If you don't, then there's always this threat of somebody else going to claim it coming along. You know, somebody else is going to claim it coming along. So think about that protection, right? So this is a summary. Copyright is honored by the works. You register it with MIPO. Trademarks, proprietors, there's a Registrar of Trademarks office. You can register a trademark either domestically or internationally. If internationally, you pay more for the registration. Domestically, you pay less, but you get the protection. Nowadays, most people I advise is to go internationally because the web has basically made every idea international, every mark international. Patents, owner of the invention, registrable at a national and international level. Again, it's a cost element. And you may want to think about whether it's something that's useful internationally or not. If it's only the best way to make nasi lemak may be a great process, but it's unlikely to be used in Scandinavia. So local registration may be enough, right? So you got to weigh that up. But do protect those ideas. Yep. First. I think then you're taking a risk. Put it this way, if the challenge is going to come, you want the challenge to come before you invest a lot of money. Rather than you invest a lot of money, you've developed the whole thing and then to discover that somebody else has got a patent. You lose out. So yes, there is always the threat that if you put it out, because there is a publication and other people will come forward, that's why the timing of it is important. But if you are at the point where you're starting to get big, that's the time to get the protection, because your loss will be capped by the fact that you haven't really invested a lot yet. But if you take the risk and go on and then you've got 20 factories and you're up to your head in debt, and then somebody comes and challenges the patent successfully, you're sunk. So my advice is always, if there's going to be a challenge, it's better to know earlier than later. Okay? Yep.
Sir, can you write your own patent, submission?
You can, but it's not advisable. Mainly because they will reject if you can't show the uniqueness, and there's a very technical language that is employed. Patent writers would be the best place. Patents don't cost a lot. They don't cost a lot to register.
Because I did ask, there were like 10K going through a lawyer, but I myself have worked with patent lawyers and I've written patents for them.
Yeah, if you have written patents, then I would say go ahead and do it yourself. You don't need to be a lawyer to register a patent, but you may need a patent agent.
And that's not in the cost that you stated.
Which cost am I talking about? Oh, this is the registration costs. This is not the drafting costs and all that. Yeah? But bear in mind of this, because I get this argument about the cost of lawyers. Weigh it against the loss that you might suffer. Don't weigh it against the gain. Because this is an inoculation. It is not a business advantage. It's not a revenue earner. The question is, how much will I lose if I don't? What's the potential loss that I have? Now, if the amount you're paying is going to be insignificant to the amount of the loss, then my advice is go for it. But if it's significant in respect to the loss you're risking, then stay out of it. You know, it's a cost-benefit analysis. But its cost is not against revenue, it's cost against loss. It's like insurance. You buy insurance because you say, I pay so much, but if I get sick, I get this kind of protection. You might never get sick, but if you do, it's worth it. If the cost is almost the same as the cost of treatment, then don't pay insurance. Might as well pay for the treatment. So it's the same kind of idea where the law is concerned here. It's an inoculation. It's a protection. It's not meant to give you an additional form of revenue, an additional advantage on revenue. Okay? Yeah, but if you have experience in writing patents, by all means, go ahead and put it through. But the language is fairly technical, depending on the invention. Okay, I have been advised that I should stop for 10 minutes. I think Sherry here knows that once I start, I can sometimes have difficulty stopping. So 10-minute break, everyone? Okay? 10 minutes? So now you've got your idea, you've got your ownership, and now you want to take it to the next level. Now the idea is ready to go commercial. So what do we need? What everybody needs, financing. Where do we get it? Now basically in law there are two types of financing and they have different consequences. And once you go down one route, you are stuck because there's no turning back. So you got to make this decision quite carefully as to what kind of financing you want. It also boils down to sharing of risk, how your risk is going to be split up. Now the two big areas is either debt financing, where basically you go and borrow money from people. They don't get a share in the company, they don't get a share of the idea, but you have to pay them back, and usually you have to pay interest on the monies you borrow. But the idea remains yours. The other form is equity financing, where they give you money to get a share of your idea or of the company or of the vehicle you're using to develop it. Now, the big difference is this. If your idea takes off, right, and becomes huge, you want it to be debt financing. Because the amount you pay plus interest will always be less than the worth of your company or your idea, because it's taken off in a big way. But if you're worried about whether it's going to be successful or not, and you don't want to take the risk, you're worried about being able to pay back, then equity financing is better. Because then whoever is putting in the money is sharing the risk with you. So if the person takes 20%, he's taking 20% of the risk. If he takes 10%, he's taking 10% of the risk. And the amount you have to pay back is capped at that level. So big difference between the two. Now there is another point where this becomes relevant, and this is at the end of the cycle. Because let's say your idea is finished, you've launched it, it's going great, everybody has bought it, and now it's time to wind up your vehicle, wind up the joint venture or wind up the company. And the rule in law is always debt before capital. The debtors get paid first, the equity holders get paid next. So if the company, say for some reason, becomes insolvent, the debtors will be protected first, and only anything surplus will go to the equity holders. Right? So again, it's risk. If the chap came along with you for the ride and is taking 10% of the risk, he is in no better position than you at the winding up of the company. His proportion is just 10%, that's it. 10% of zero is zero still, so that's that. Okay? Yep. Okay, there are always strings attached. No such thing as a free lunch. Well, in Malaysia, no such thing as a free breakfast, lunch, or dinner. Debt financing is always your cash and interest. You've got to worry about that. Of course, if you get debt financing, there's less cash in hand because you've got to make your payments back on a regular basis, depending on the type of financing. But usually there has to be a portion set aside to repay. Your risk is not shared. You bear effectively the whole risk of the enterprise. The debt is an additional burden that becomes part of the risk. The bank is protected either way. Whether you're successful or not, the bank will get back its return. Your payment terms are fixed. You can't adjust it without the consent of the bank. Equity holders, you can always talk to them and say, okay, look, we are at a point of great in capital investment, so let's not declare dividends for the next 3 to 4 years. You can make that decision and keep the money in for development. That's the flexibility you have. You don't have that with the bank because you have to pay at a predetermined time, a fixed time. Your interest is tax deductible, small benefit. And debt unfortunately carries a reputational risk. If your debt is high, in terms of financing, it's harder to get more financing. Your debt levels are too high, you become a high risk factor. And then usually banks don't like to be unprotected. They will ask for some kind of guarantee to give personal guarantees, or the directors of your company give guarantees, or they'll ask for some assets that they can hold as security. Quite recently, actually last year, MIPO came up with a form of valuation of IP rights. So if you have a patent, the bank can actually value it and they can take it as security for a loan. So you repay it, you get the patent back. If you don't repay it, then the patent becomes theirs to sell off and get right. So that's one form of asset you can use to charge. Frankly speaking, if your idea is good, I wouldn't risk the patent that way. If your idea is good, you'll find people who are willing to finance you. So that is probably not the way to go. If you're on the equity side, the profits will have to be divided. You don't get the full sum. One of the guys who probably benefited the most from this was, what's his name now? He is an English actor. This is really age showing now. I can't remember his name, but he played Obi-Wan Kenobi in Star Wars. Anybody know his name? No, not John Gielgud. Alec Guinness. Alec Guinness, when they did Star Wars, the first one, Alec Guinness' fee was too high. They couldn't pay him. So Alec Guinness said, okay, never mind, you just give me 1% of the revenue. Nobody expected Star Wars to become the hit that it was. He earned more than anybody else on that cast because of his 1%. He kept earning when because the movie's still been going on for years and years and years. We got the new one coming up in December. But 1% was his take, and he earned from it. So sometimes your person who shares your idea will be willing to take the risk. They're willing to come along for the ride because they want to make on that 1%. Investors and partners usually don't expect large returns immediately. The good thing about having an investor on the equity side is that you can talk to the person and say, look, these are the expectations, these are how it is. It's a partnership in a true sense. Banks originally, way back in the 1920s and 30s, were partnerships with enterprises. Now the only banks which do that are investment banks. Your normal bank is purely a lender. He doesn't know what your business is, he doesn't know how you run it. He leaves you alone, but he expects the money back. So you want to be on this side of it if your idea is good and worth running forward. Sometimes small loans at the beginning are a great idea for development of your idea to see whether it's viable or not. And then when you get an investor in, you can pay off the bank and then go on a partnership. That's the other model, a hybrid of the two. But it's something you need to think about at the beginning, because once you take that step, there's no quick fix. You have to run the course. If you take a loan, you've got to repay it. If you get an investor in, you can't tell him go away tomorrow. So those decisions are long-term decisions that need to be made at the time you want to take your idea forward. Next slide, please. Debt or equity financing is a question of finding the right balance. It's tough. It's tough because all of us would like to see the future, but none of us can. So you have to take calculated risks, understand where your idea is going to go. Maybe some market research even is required. So you just have to consider it, and then you think about which suits you best. Here's some options. Think about the type of your type of business. If it's a type of business which requires a lot of recurring finance, then that is probably a good idea. The operating cost can be on a revolving finance basis. Some kind of overdraft facility would probably be good, and go down that way. Your industry, if it is highly competitive, look for equity investment. Why? You're sharing the risk. You're in a highly competitive environment. There is a greater risk in a highly competitive environment. It might be better to share the risk. If there are high barriers to entry, then also look at an investor. The investor might help you get over that barrier. In certain countries, if you want to go into the country, you need anyway a person who is a local to get you entry into the company because of regulations. Then you start saying, okay, maybe equity financing. Let the person share the risk with me. It's their territory after all. Cash flow, is it one time or recurring? Right? One time cash flow, investor looks good. Recurring finance probably better. You can roll the financing. Expansion plans, the value of your assets, size of financing, management, etc., etc. And of course your last one, if you got patentable technology, if your idea is at the point where you can already register patent, you now have an asset that can be valued and can be used for financing. An idea which is not patentable is not yet an asset that can be used for financing. Can't use it as security. So these are the questions that you may have to ask. Might be an idea also at this stage to actually get some kind of financial advisor on board, if you're in it for the long term. Because at some point in time, you will need a financial advisor if you're in it for the long term. That's the whole idea, isn't it? If you're going to grow, you will need someone to look after finance. So let the guy come in early. But if you're in a limited, you're thinking of a 4-year program, 5-year program, maybe even 10-year program, then maybe not. You're thinking about short term, you're going to wind it up anyway, it's not going to grow beyond that, then perhaps not. Examples of financing, because banks, friendly investors, friends, relatives. It's amazing the number of movies in the US which are actually funded by family members. The smaller independent movies are generally funded by family members of the movie maker. And when he makes it big, they make it big. The original Desperado was made for $100,000 US, funded by 10 family members of the original director. Of course, sold it for a bundle to the Hollywood cinema, who then made the version with Salma Hayek and who was the other guy? You know him. Puss in Boots, yes. Yeah, Antonio Banderas, yes. Right, so that's another form. Leasing is another idea. That's renting. Financing renting. If you basically, it's premises and stuff like that, think about rental rather than purchase. Equipment rental rather than purchase. That's a form of cutting your costs down and spreading your financing. Moderate forms, you can look for grants, government. Sometimes people exchange, do exchanges. Factoring is another way where people bundle up debts and share it among different lenders. They're moderate forms. Usually these are one-off kind of situations. Equity financing is bootstrapping. These are the ones people are more familiar with. I know in the entrepreneur community, this is generally where people talk about things. But really, this is financing when the idea is a bit developed. But you don't get there on day one. You get there after the idea gets to a point where it's developed. These are alternatives that are worth considering in the development stage, right? That bootstrapping, venture capitalists, crowdfunding, this is gaining a lot of popularity now. And there is an attempt to try and institutionalize crowdfunding in the country. M&As is basically finding another company doing the same thing and joining up. Then going for listing, well, this way down the scale. But you look at these two, will tell you what happens. Your obligations increase on debt, profit control and certainty decrease on equity, towards equity. That means your share of the profits, all this will be, the more equity you have, the less profit you yourself will get because you're sharing it. But your obligations are low. Here your obligations are high because you have to bear the debt. Okay? Everybody wants to be secure. Yeah. Basically, whenever debt is involved, people want to have something to hold, some kind of security. One of the best things that has happened is the valuation of IP rights, because that is what you're banking it on, and because that has value, you can give it as security, because the idea has become monetized. It's now got a value attached to it, and that can be used security. But normally you would need, on the early days, if you need money for financing and you're looking at debt, you need some form of security. Land, property, IP rights, equipment, something, okay? Unless your idea is really so good that everybody grabs it from day one, that is what you need to look at, right? This last line actually is a new area, because until a few years back, there was no formula for monetizing. Banks would not take IP rights as security because they didn't know how to value it. But now there is a method in place, so that's some value there. Types of collateral, yep, real property. Sometimes if you've already got a business running, your cash flow or revenue can be security. You know, so the way it works is the bank will say, whatever money is coming, you put in my bank. That's I pay you, give you a debt, but whatever monies you receive go straight in my bank. You can take it out again, but as long as I know there's a flow of money, I'm happy because I know you can repay. Now that's not a bad way of getting your debt financing going. Savings bonds, stocks, mutual funds, assets, IP, anything with title of ownership, usually land, but really anything which has got a title that you can run with it. Long-term purchases, and of course personal guarantees. Generally, if you're a company, the directors will have to give personal guarantees. That's standard banking practice. If you have a company, the directors have to be prepared to give personal guarantees. Loans and financials available. Okay, if you are a startup, okay, and you can convince the guys that you've got something that is viable and it's ongoing, you already have to be in trade, so to speak, you usually can get away with no collateral, basically by using the financing through the bank. Remember, the banks make money by, if you deposit money in the bank doesn't keep it there, it goes and lends it out and gets interest. So there is a benefit to the bank for a constant flow of cash coming in and going out. So if you are a startup or an SME, your options will probably not require a lot of collateral. Sometimes, depending on the type of enterprise you are, there may be guarantees that you might get from government if they are promotional areas where government is promoting. One of the things that is always good to have and keep updated is your own list of assets and liabilities, because it will let you know what kind of financing you can get. I know in the law firm this happens, and I'm pretty sure it happens in businesses as well, especially when you don't have someone separate looking after finance. We bill the least when we are most busy. We collect the least when we are busiest. Why? Because we're so busy doing things, we're not looking at the funding and the financing. It's only when we are not busy that we say, anybody pay the bills yet? You know, have we sent the bills out in the first place? And it's a normal pattern, it's a behavioral thing. When you're most busy, finance goes to the back burner, unless someone is dedicated looking at it. And when you're least busy, that's when you're bringing it up to the fore. So you need to keep this around, because if you need sudden urgent financing, you must know what you have to be able to get financing on. You know, update your valuation of your IP rights, for example. Do it on a regular basis, regular review, because if your idea is good, your business is growing, those rights are carrying greater value. Okay. I think just give it a second, it'll be back on. So keep that updated. The other way is always keep a lookout for, especially on expanding business, for other investors coming in. Now bear in mind that where debt is concerned, it doesn't matter who lends to you, really. It has to be a proper lender, but it doesn't matter, because they're not going to get involved in your business. But if you're going to equity financing, you better make sure that the person who's becoming your co-shareholder is someone you can work with. Because if you end up having a dispute, it is impossible to push the co-shareholder out. You're going to be stuck in a dispute. So that relationship is important, to know who your fellow shareholders are. There we are. Now, creditors is anyone whom you owe money, or your company owes money, and these are the things that will need to be looked at, repayment schedules and all that. The reason I put this up here, and I'm going to skim over it because going into it is going to be complex, but the point is this. This is the point where you really need to be sure what the arrangement is. You really need to be sure what your commitment is. There is a lot of fine print. There is a lot of fine print. Guarantors, for example, always seem to have the idea that only if the borrower doesn't pay, I have to pay. That is not the case. The financier can call directly from the guarantor without calling for the borrower. You need to know what your obligations are. If there is a default, what exactly do I have to do? Do I pay the whole sum back? Do I just have to pay the arrears first? What do I have to do? Now, these are things that you need to look at when you look at the financing package. Equity side, you need your business plan going. Your cost, expenses and fees are necessary, they're sunk costs. So no matter whether you go equity or borrowings, this is the minimum amount you need to get. If you get anything less than the minimum, you can't take off. So you got to look at that. If you got interest, there are late payment charges. You know, when the global financial crisis hit and there were derivatives that had to be interpreted, they took those clauses and gave it to 4 different people, and all of them disagreed as to the amount of interest to be repaid. The interest workings were so complex that nobody knew exactly how much interest was chargeable. And if you read banking clauses, you will find that it is really worded in a language which I think nobody understands, even the bankers. It is convoluted, it's got, I've seen an interest clause which is a page long, 1 sentence. How to work out how much I'm going to pay back? You know, it's very complex drafting. It's the kind of drafting that you become like me, bald, because you pull your hair out. You know, it's really complex. So be very clear when you do that, what your obligations are, right? Also bear in mind that usually there are access to your financial information accounts that will be required. Yep?
Is it lawful to
Yep.
Whole thing.
Unfortunately, the answer is yes. You see, it works this way. Maybe I can explain to you. It works this way because the concept, reality and concepts never work together. One. The concept is, if you don't agree, don't sign. If you don't understand, don't sign.
It's based on interpretation. I interpret it differently from you,
Yeah, which is when they will say, well, you should have cleared it up at the beginning.
but I thought I knew it that way.
Then you go to court and the court will have to interpret. So that's why even things like correspondence, for example, if a clause is not clear, absolutely in order to turn around and say, look, can you explain to me exactly what this means? Right? If I owe you $10,000 and I don't pay it on time, exactly how much interest do I have to pay you? Now, if they give you an answer, they're stuck with that answer. If they don't give you an answer, then you know you're running into trouble. Right? That's why you got to document it. That's why the documentation, the trail is very, very important. If they give me verbally, I'll write them a letter to say, thank you for letting me know that this is only how much I have to pay back. It's on record. A lot of times, problems arise not because things have not been agreed. They have been agreed, but nobody's documented it. And 5 years, 6 years down the line, everybody's forgotten. Or everybody thinks they remember, but the remembrance is different. So the documentary trail, especially on financing documentation, is critical. Now there is a movement, quite a few of us lawyers that are moving towards getting things understandable so that people can actually work with it. We call it a plain English movement so that you know exactly what it is. If there's a penalty clause, for example, make it bold and put in a box or something so that information gets across. But traditional drafting is not like that. Traditional drafting is convoluted, it's complex. There's only one place where plain English that I know will not catch, which is in Indonesia. And I'm not joking. In Indonesia, if the client understands the clause you've drafted, he thinks you haven't done your job. If he doesn't understand it, he thinks the lawyer has done his work. So our Indonesian office is the only one which is allowed not to draft in plain English. The rest of us, it's a whole question of getting the meaning across. But not all documents are like that, and banks are especially because their documents were drafted some 30 years ago by some guy, and to change it is like moving mountains. So even the local banker will not dare amend his document. So these standard form documents have to be very, very carefully dealt with. I know, I'll tell you, I'm a lawyer, and I do this myself. Give me the document, I'll sign it, I'll read it when there's a problem. But that's too late, really, isn't it? There is a necessity at this stage, at the beginning, to get it right. Okay? Once debt is repaid, that's it. Financier goes away, you carry on. With equity, it's a marriage for life. You cannot tell someone who owns a stake in your idea or in your company to go away. He has to make the decision to go away. You're tied up forever and ever. There are mechanisms to push people out of companies, but they're painful and they're long, and there will always be reputational loss, always. So you have to be very careful when you bring in joint investors. Even if they are angel investors, you need to know them, they need to know you. They need to know how long ideas are going to take to mature. You need to be sure that there is an element of flexibility in the relationship, that you can change the terms as you go along. This all has to be determined at the beginning. That's if you go for equity financing. Okay? Yeah. There is actually no law here. The lawyers will never tell you this because otherwise they get no work. The basis of all this is basically the freedom to contract. Parties are free to agree whatever they want to agree. The problem really is unequal bargaining power. The larger the institution, the greater the bargaining power. The smaller the player, the smaller the bargaining power. But really, in law, it is all up for grabs. Up to you guys to agree. When does the title to property pass? You agree for it and put it down in an agreement. When does ownership of the patent get lost? You agree about it and put it down on the patent, in an agreement. So all that is a matter of agreement. And that's why it's a relationship business at the beginning. Until you get big and become impersonal corporation, it's all relationships. You need to understand the relationships. Financing contracts are no different. The power is in the hands of the parties to decide. So don't just accept the agreement that is given to you. Make sure that you get someone to tell you, to advise you, what does this actually mean? What does this actually entail? And if you cannot live with it, don't live with it. There are other people who are prepared to finance. You know? It is important to get this right because this will survive for years. It's not a one-stop. The financing will go on for years. The equity will go on forever. So be careful about this. This is a good time actually to see legal advisors, independent legal advisors, and tell them, look, this is what is being offered. Can you make sure that, let me know what is it that is here. What exactly are the commitments? I want this to be changed. Can you negotiate with the bank or the institution for it to be changed? This is a good time to bring them in. The bank will have its own lawyers, but they are not going to look after your interest. That's not their job. You need someone of your own. Okay? Parties to financing can never be forced to act. So, yeah, basically be wary. Okay? The other thing is that in Malaysian law, the only thing that a person is allowed to get back for a breach of a contract is compensation. They are not allowed to make profit out of it. So, if the bank is going to charge you exorbitant penalty rates, it can be challenged. Just because the bank says it can't be challenged doesn't mean you can't challenge it. It's got to be reasonable, and reasonable is taken to be what generally the market rates are. So if your interest rates is, your default interest rates is worked out at 8% per annum, that's okay. That's what most people charge. If it's 20%, no way. You don't have to pay. The bank has to establish that that is their loss. The court will turn around and say, everybody else is living with 8, why do you need 20? It will be cut down. That is the law in Malaysia, right? Specific performance is getting the bank to do what it says it will do, and that is discretionary. Now this sometimes happens when there is a promise that money will come in separate tranches. I give you so much now, I give you so much more next year, and I give you a third drawdown in 3 years. You cannot force those drawdowns. The law will not allow you to force those drawdowns. But you can get damages, the losses you suffer because of failure to draw down. You know, so just bear these general principles in mind. It's not right. Okay. Okay, when finance is not enough, the other things that you need to look at when you're growing, this is at the growth stage already. You got the idea, it's valued, you're up and running into business. These are other stuff that you need to look at. All of them will be founded on contract. Will be a matter for agreement. And if there is one takeaway from here, the idea is whatever happens, it better be documented, because disputes are decided not on rights and wrongs, but on documented and undocumented. Remember, the judge who is hearing your disputes hasn't been with this transaction from the beginning. He doesn't know who to believe and who not to believe. To swing it, you need the evidence, you need the records, you need the story. And the better documented you are, the more likely you are to succeed. Okay, so it's all of that. Trained workforce, that's employment issues, clientele, marketing, that deals with entry into different markets and what restrictions there are, property, intellectual property, industry experience, branding, business development, cross-marketing, all of them contractually based. Generally speaking, Currently, joint ventures and strategic partnerships are probably the way to go because the expertise now has become so specialized that you need a specialist at that stage when you're making the leap up from small to regional or nationwide or something. You know, by the time you learn about marketing, it may be too late. Things move along. So getting a partnership with somebody or a group of people who can provide you the gaps in your business and entering into strategic partnerships with them is useful. Joint ventures are useful if you have a company and you want to set up in, say, Sabah, right? I don't know what the market conditions in Sabah, but there is this guy that I know who is runs a marketing firm, does advertising in Sabah, knows the market. For me to move fast, it's easier for me to tell him, look, you put 50% in, I put 50% in, we form a company, I will give you the ideas, you do the marketing, you sell it in Sabah. You've covered your marketing, you get 50% of the profits, he gets 50% of the profits, but you're already in the territory. If you're going to do it yourself, it's going to take time. So strategic partnerships and joint ventures at the growth stage is the time to look at it. It's a much faster and cheaper way of growing businesses. Risk is shared. You get into territories really fast. And generally speaking, because the people are on the ground or experts in their fields, your confidence levels are going to be higher. Confidence in the business is going to be higher. If you team up with no names. That is why a lot of the tech companies are quite happy to tie up with other tech companies. The small ones tie up with the large ones. Google has got lots and lots of joint ventures going along. Microsoft has got tons of joint ventures going along. Why? Because the smaller guy can't get the kind of access that Microsoft can. Microsoft doesn't have the time to develop the idea that the small guy has. So they work together and the JV takes off. Okay. The beware was because the usual, be careful of the boss. The big guy will always try and lord it over you. That management structures come in. The good, the bad, and the ugly. Well, you got to pick the right guy firstly. You can't pick competitors if you're going into a market. You can't say, I want to be with two different marketing guys in my partnership. That's a disaster, recipe for disaster. They will start disagreeing and competing with each other. So you want to pick one industry player, the guy that you know. You got to think about the structure of your joint venture company. Who gets the right to vote? What things do you want to have a say in? These are known as reserve matters. Maybe certain things you want both parties to agree. So you will say that this is not going to be majority rules, both of us have to agree. Let's say expansion plans. Let's say the selection of the CEO. Those are matters that can be agreed. Voting rights. Maybe certain things you want to have the veto. The right to bring in a new partner, a new member into a new company into the shareholding. You want to have the veto because they may be your competitor. So that things to look out. When you're forming ventures of this sort, buyout provisions are always encouraged because you don't get into a deadlock. There may come a time when you and your shareholder, your joint venture may not agree. We had a joint venture with a law firm in Singapore. The idea was we both go regional. It was a great idea. We were both going along the same path. But it came a time when the global financial crisis hit. We pursued the ASEAN route. They wanted to go back and concentrate in Singapore. Fine. But how do we dismantle? There has to be a process to dismantle the venture, and that was a simple buyout. Okay, we value the shares that you have. I buy your shares. You go do your thing. I'll go find another person. So there's that buyout provisions, and exit options, basically. Generally speaking, shareholding, although they're not a partnership in the sense of a true partnership, in an entrepreneurial situation, you are effectively working as partners. You want your shareholders to work for the company, unless they are, angel investors or venture capitalists who basically stand outside. But generally, you want to bring people into the company who will assist the company. And they will have an incentive to assist if they sense a sense of fairness in the profits they're going to get out of it. If he puts in lots of effort but his only return is 1%, he's not going to work for the company. So you got to make sure your equity spread is fair, the value is fair. The relationship has to be one that can stand through thick and thin. When you expand, there will be challenges. Is the person the kind of person who will stand with you? Yeah. Yeah? Sure? Okay. And of course, exposure, reputational risk. If your partner collapses tomorrow, you might collapse the day after because he's your partner. Your reputation is tied up. Okay? Avoid deadlocks. Always have a mechanism to avoid deadlocks. Yeah. Let's move. These are other things of types of joint ventures. They don't have to be corporate. They can be by contract. Typically agency. I have a company here. I want to distribute in, I've got an idea, I've got a product, I want to distribute it in Thailand. I don't want to have a company and equity there. I might go into an agency, appoint an agent there. But he has to be someone you can work with and all the usual things. So the top part are all by contract. These are when you actually form companies. And sometimes you can do the crowdsourcing technique, public-private companies. Either joint venture with a government agency or joint venture with crowd-funded entities who basically act like stakeholders. Okay. When do you think of partnership and LLPs? That's generally it. These slides are going to be made available, so I'm not going to run through it. But if there's any questions you want to raise on that, please let me know. I've been given the message about hurrying it up. Contracts. This is the last one, isn't it? Okay. Okay, this is just what a contract is. It's just an agreement between two people. It's no more magical than that, right? The difference with a contract is that you parties expect to be bound by each other. If I invite my friend here for dinner and I don't turn up, he's not going to sue me. I'm not sure about him, but generally he won't sue me. Okay? But if you enter into a business relationship, you expect obligations to be respected. So that is fine. It does not have to be written. The written document is the evidence of the contract. It is not the contract. The contract is the agreement itself, right? But you got to look out for fine print and standard form contracts especially. Standard form contracts, as a rule, will be one-sided. Why? Because only one party is writing them. So you got to be careful about standard forms. Entrepreneurship contracts these are the standard ones. M&As or constitutions are when you start an organization or a company. Your joint venture, that's where all your terms will be settled. What your voting rights are, what your share, voting, how you're going to vote, what matters need the consent of both parties, what matters need special res, all that will be there. You've got contracts with your suppliers for goods and services. Then you may have a master agreement, and then with purchase orders and things down the line. Employment contracts, leases, that's when you get premises, sale and purchase and tenancies, JVs, inventions. Basically anything that you do where you expect someone else to have an obligation to you or you to have an obligation to someone else will be a contract. So this area is the one which needs documentation. We've done this already, so we can skip. Actually, it is the same slide. Okay, boilerplates. Boilerplates are what we call standard clauses. They are extremely dangerous. They're extremely dangerous. The reason they're dangerous is nobody actually reads standard clauses. They think they know, so they don't read. This is the danger of cut and paste lah. Standard clauses, cut and paste. So you get things like, I had one case where I was defending the owner of a bus who had gone around the corner and clipped the pillar of a shop, and the shop lot had basically collapsed. And the guy who drafted it said that, cut and paste, that the shop was negligent for being in the wrong place. And I was thinking, yeah, right. Cut and paste, never thought about what was in the context of the contract. So boilerplates are these terms which you will find in almost every standard contract, but you need to look at them. The choice of law clause is especially important. Nobody tells you this, but you can actually choose what law applies to your contract. It doesn't have to be Malaysian. We can agree that Singapore law applies. We can agree that English law applies. We can agree that the law of, there's no undertaken law, so the law of Sweden applies. It's up to us. Contract is pure agreement. Yeah? And you can also decide where the dispute will be heard. That if you and I have an disagreement, the courts in Singapore will hear us. The courts in Thailand will hear us. Doesn't have to be Malaysia, right? And you can even decide that the courts not hear you. You can say if there's a dispute, we will go to arbitration. If there's a dispute before we go to court, both CEOs must try and solve it. You can build this all into that clause. It is a very powerful clause when it comes to sorting out disputes. The trouble is because they think it's a boilerplate, nobody looks at it. But really, the best time to look at a dispute clause is when people are happy. You sign your agreement, everything's going fine. That is the time to say, look, if we have a disagreement, how are we going to deal with it? The wrong time to look at it is when you have a disagreement, because you're never going to agree on what these clauses are going to be. So right at the beginning, look at your dispute resolution clause. Partial invalidity mainly means if one clause is out, we just kick it out, the rest of the contract is fine, that's okay. Communications is important as well, because you can actually tell how we communicate with each other, maybe by email, that official communication by email, maybe faxes, maybe you want a particular address, you can put it in. Important to put in because as time goes on, relationship is good, no problem. Relationship goes bad, then you'll be arguing about, did you give me notice, didn't you give me notice? Where did you send it? When did you send it? How did you send it? All that will come in. So look at that clause as well. Variation of terms is basically when you can change terms. Force majeure mainly means that if something unexpected happens. You know, we all go to law school and learn a dead language. Floods, all our servers are underwater. How to do service? So what happens? These are the clauses that look after it. Generally speaking, you will look at common disasters, disaster recovery and things like that. Interpretation, ancillary, commencement, warranties, guarantees and indemnities are what will be compensated. So if you breach a warranty, then does it mean the agreement is off? Or is it enough that you just pay me a certain amount? Depends on how important the thing is. So you have to work that out. A dispute settlement ties up with your jurisdictional clause. Next one, please. Oh, that's all. Okay, where next? Got 20 minutes for questions. Oh no, okay, never mind. I'll still give 20 minutes. So now you're up and running, your idea is up, you've got your inoculation, you've talked to the lawyers the right time, your idea is concluded, you then make new agreements and you move your company forward, you expand to other jurisdictions. Laws in different jurisdictions are different. So if you're going into unknown territory, you need to know what is allowed and not allowed in that territory. So it's important to get proper advice at that time. Speaking from the point of view of lawyers, and I'm not speaking specifically from the profession as a whole, but the most important thing that I found in the practice of law over the last 28 or 30 years, I always think that we call it practice because we never quite get it right. but is that relationship matters, trust matters. You can do great things for a person you have a relationship with, who trusts you and you trust them. If you don't have a good relationship and there is no trust, a lot of time is wasted because a lot of advice given is not taken, a lot of information is not given. You don't have that flow. So you look for people who will go with you for the ride, who you can trust at the beginning and who will develop the relationship as you go. You know, to businessmen, an agreement is a handshake on the golf course. To lawyers, there are agreements about that thick where nothing can change. They are talking different languages. You need someone who understands your business, who can grow with it, who knows where you want to take it, can advise you on the different steps of the way, or find you the right people to advise you on the different steps of the way. And at the end of it, you will both come out of it better. You know, so that is the key, whoever your advisor is, to find it. What I've given you is just an overview. You basically at the beginning, you need to get in people so that they can advise you what route to take, develop an idea, when's the best time to incorporate. At the point of incorporation, if you're bringing in other partners, they are the best people to tell you, look, voting rights, structure, how do we go? When financing comes, to understand your obligations, not necessarily to draw the contracts up, to understand the obligations. And towards the end, how are we going to divide up the profits? How are we going to wind up the company? How are we going to move on with our lives beyond that? So those are the stages. This is going to be made available online, so you can have a look at it. And with that, we'll see whether you guys got any questions. I know lunchtime, you're usually very hungry already. Oh yeah, I understand that you guys have to evaluate me. Please be kind. Any questions? Yep.
About the filing the patent and trademark, how much roughly does it cost to file
Not much more, not much more. It depends on how many different countries you want to cover. So it's like, you want to cover the whole world, then that's a lot lah. So basically you look at where you intend to do your business, and that's the areas you would cover, you know. And then later on, if you want to go to further countries, then you just extend it, keep going. Yep. Sorry, I can't hear.
How important is licensing agreement? Right, that is with the merchants, and EULA, that's with the end customers.
Okay.
At the very beginning.
Licensing agreement is critical because not so much for the license itself, but the restrictions that might come with the license. So it has to fit your business model. So when you look at the licensing agreement, if it doesn't allow things that are the areas you want to develop in, like certain licenses may not allow you to develop certain products or certain lines, but that's the area you want to go in. Then you have to go back and say, look, that's where we need to sort out this license. I need to have access, especially if you're doing software development codes, source codes. End user, same thing. There you're thinking in terms of protection to yourself. If you're developing something, you don't want to pass it down to an end user who will then develop the same idea in competition with you. So there you may put in a restriction that these ideas, go leave with me, you don't develop them. So yeah, licensing agreements are important. But again, willing buyer, willing seller, you have the say. Both parties have the say what those terms can be. Okay?
Right now, nowadays, the recommended model is always to start small and you iterate very often.
Yep.
So then that will affect the EULA.
Yep.
And that's constant changing, and that will eat into the legal fees that
No, you can work the EULA so that it covers any future iterations or a certain number of iterations. Again, like I said, you know, there's no magic here because it ultimately, well, there is magic here, but But it really is a question of what the parties agree. If I agree that every iteration, the license will cover this and the next 4 iterations, then that's what it'll cover. But if I don't, then it's going to be each one separate. So it's again agreement on what the license should be. Okay, yes?
What's the typical standard rate for contracts, say, between startups and third-party vendors like manufacturers?
It depends on the business and what the startup is doing. There are no standard rates really, because pretty much every good contract is really a customized contract, because it takes into account.
An estimation of how scary the numbers are.
Well, let me put it this way: I will be really, really surprised if they go beyond, say, 4 digits or 5 digits. You know, it depends on how complex. Like if I was doing an agreement between someone who's designing a new manufacturing line for Honda, that's going to be an extremely complex agreement, not the usual one.
Typical startup situation.
Depends on what you're doing.
On average,
It's very hard to say. I mean, I've seen contracts that's 300 years ago, 500 years ago, 10,000 years ago. Depends on the process, depends on what the relationship is. But I can tell you this much, generally speaking, they're comparable to the kind of losses you're protecting against. Generally speaking, I'm not saying in all cases. In some cases, there's a real question as to whether it's worth it. You know, but generally speaking, even customized contracts, 10, 15 at the most would be your standard. Again, complexity, I can't give you a ballpark figure because frankly speaking, you can get a standard contract, but the one thing I can tell you is probably won't work, because your business, the whole idea of an entrepreneur is coming up with something new. If it's new, nobody's done a contract for it before. So it's got to be if it's already been done before, then it's not new. So entrepreneurship, especially new ideas with new parties, you got to look at the relationship and how it goes. But the cost, if you're thinking they're going to go in hundreds of thousands, it's not. Definitely not. 50 also, I'll be very surprised. It'll be below that. But exactly where in that range, I can't tell you without knowing the complexity, or even how deep the involvement will be. If the person is coming in purely as a shareholder, it's a straightforward contract. If the person is coming in and wants voting rights, and he wants a say on the board, and he wants to have a look at your business plan before he gives approval, that contract is going to cost a bit more. It's going to look at other things as well. So, but my advice is this: don't be scared until you ask somebody and they give you a number. That's my advice, because you have to make, and I understand, you have to make the decision on a cost-benefit analysis. Quite understand that, perfectly understand that. But I always get the idea that people think it costs more than it actually does. And because of that, they don't take the step of asking. And then you run up into big problems, tail-end problems, when you can't get out because you didn't spend a little at the beginning. Like insurance, exactly like insurance. So go and ask. In fact, the best thing is to ask 3 or 4 people. You know what the good thing about lawyers is? Unlike doctors, you don't have to pay for consultation. Have you ever gone to a doctor and not paid cash? Lawyers never collect it when you go and see them. You ask for a quotation, they'll give it to you. And you can compare and see what you want. But to be honest, again, the main thing is make sure you end up with someone you're comfortable with, and if you're going to think of it long term, someone you can work with for a long time. It's important. Anything else? Yep.
LLP, from your slides earlier, you're saying it's only relevant to certain businesses, certain industries.
No.
There was a slide
It's relevant in the sense of the nature of it. Manufacturers will generally not be LLPs. They can be, but really the business is not built for that. Startups, some of it will. If you've got early partnerships where you don't want to spend a lot of cost, LLP will be viable. Legal firms almost certainly, because they're not allowed to incorporate. So the LLP is a viable model. So it depends on there's no legal restriction on who can be an LLP. Anybody can. But in terms of the nature of the business, you're looking at services, you're looking at initial stages of a startup situation with more than one party involved. That's when it'll probably be the most useful. Okay? Anyone else? Yes. Okay, there is a ongoing argument. You never argue with the tax department, you just listen. There's an ongoing argument with the tax department. Strictly speaking, most of us feel, because it's a new entry, most of us feel that it should be tax neutral. That means what I was paying as a partnership should be the same tax I'm paying as an LLP. But the tax department is looking at it and saying, look, that's a lot of work for us, because partnership means each partner files their own tax return. That means you got 20 partners, I got 20 returns to fool around with. Whereas if you guys are just one company, there's only one return. So the tax department wants to go down the route of treating it like a company, one return. Doesn't matter how many shareholders, doesn't matter how many partners, one return. And then you fix the rate. They are at the moment looking at a rate slightly below what corporate rate is. But knowing tax department, they'll try and get the number to be the same eventually. But from the partnership point of view, from those who are partners or looking to become an LP, they're saying, look, this is not meant to be a revenue earner. This is meant to be a vehicle. So why should I pay more tax because I'm an LLP, where I can get all these deductions if I pay as an individual partner? So that argument is still going on, but it's my sense is it's going to be single rate, and the rate will be comparable, maybe 1 or 2% below your tax rate, your company rate. Okay. Anyone else? Yep.
For example, right, maybe from 10 years ago, I had an idea like YouTube, where create a platform for users to upload and share the video, right? Instead of like, if I want to bring my idea and talk to an investor, instead of asking them to sign NDA, are there any other methods like trademark or patent that I can do on my own site to protect the idea?
Yeah. If you, like for example, if you want to go and do an NDA, non-disclosure, fine, but that's you're thinking development still. But if your idea is sufficiently developed, you can go and get it trademark or patented process. Oh yeah. It's a process. You don't patent. YouTube doesn't patent YouTube. YouTube have patented the process first. Then when they got the name, that they gone and got a trademark on the name and applied it to the process. Most of the things that you see on that inventions that come up, the patents were put in years before they became commercial, because they were protecting the idea.
So they need to patent it in every country that they want to put in, or there's one patent that is applied globally?
Again, it depends on where you're going to deploy it. If you're looking at something that's going on the internet, then you would probably want a global patent. If I'm looking at something which is a manufacturing process, I'd probably just want to patent it where that process happens. So depends on where you want to use it or to utilize it.
So just curious, if this is the case, how come Apple doesn't want to patent everything globally?
Oh.
And they're going into country and country?
Well, Apple, you see what happens is that each country's patents laws do vary, and there will always be a tendency to favor home industry. So if Apple goes and does a global patent and covers Korea, it will be subject to Korean law. And Korean law might favor Samsung, so they'll go fight in Korea. In the States, it will favor Apple, so Samsung will go fight Apple. In other jurisdictions, it might be 50-50 depending on which takes dominance. You know?
Another question is, just now you mentioned that we can register our idea by sending a registered mail ourselves, right?
Only copyright.
Okay. For example, can I do the same, like I attach anything that was copyright in my email and then send it back to myself, as there will be an embedded timestamp in the email as well?
That you can. As long, I mean, basically all you need to prove is when that creative work was made by you. And that's why the date stamp is important. Okay? Yep. 20 years. Can renew. It won't last your lifetime, by the way. If you die, your patent goes public. Anyone else? Yep.
think you can renew it because it's not everyone will be renewing. I mean, drugs company will be renewing all the time.
Yeah, they can, but it's not forever and ever. There's a limitation. Drug companies are specific. There are specific rules regarding drug companies because they have generic. There is a period of patent after which generics can come in. So it depends on the nature of what you're patenting. You know, because they do allow generics to come in after a while. Patents don't work the same for different categories. They protect, but lifespan depends on the category. And again, sometimes it depends on the nature of what you're patenting. In some countries, for example, you cannot patent genome sequences. They consider that as life, that life cannot be patented. So you got that. It's not that you can get a patent forever and ever. That'll never happen. But you do have a power to extend it. Okay. You're thinking of fixed term patents.
I know. I used to work for companies like Coca Cola.
Yeah.
We are aware of the lifetime of
Yeah.
patents. That's why. I wasn't aware we can renew it because
Limited life. Limited life. Usually it depends on development. A lot of it depends on how long it takes to become commercial, because you got a commercial lifespan. So if development period is very long, then you have to be able to commercialize it. So that's the fixed timeline. Anyone else?
Anyone last question? No?
Yep. Mm. It again depends on how strategic those partners are and how long they're going to be with the enterprise. If they are going to be there as part of the manufacturing process or the development process long term, then you may want to bring them in a joint venture so that they're tied with the company, so you guys are working together. If you're thinking of them merely to go for marketing or distributing in a particular region, then you might want to think about bringing them in not as a partner, but under a distribution agreement, under some kind of licensing. So that'll be a different thing altogether. So it really depends on what business model you adopt and what your product is, and how close you want that partnership to be. The thing is, the closer the partnership, the harder to disengage. The more arm's length it is, the easier to disengage. Okay? Yep.
Okay, round of applause. Paul from ZICO.
Thank you.